Welcome to Your Business, Your Life with Matt DeFrancesco, your personal financial technician. Whether you've had years of success in your business or just starting out, Highlift Financial can help you create a vision for your business, life, and family, and align these for generational wealth. So as they say, what happens in your life affects your business. And now, on to the show. Well, hello and welcome to Your Business, Your Life with me, Matt DeFrancesco, and we're here for part 2 of comparisons of C-Corps. And again, Stuart Sorkin's with me. So we kind of left off talking about a lot of very high-level stuff. I think, what we want to do this time is just kind of start to break down some of the things that Stuart was talking about and the benefits to it. So Stuart, let's talk a little bit about, we were talking some of the comparisons of between C-Corps, S-Corps, LLCs. So let's talk a little bit about, we talked about tax rates, but some of the other issues that are out there. So I'm going to just share the screen and let's talk about what you've got up here.
Okay, so the concept here is, as I mentioned, big problem with investors in raising investor capital with S-Corp. They don't like the phantom income. They can't get a liquidation preference because that would be a second class of stock under the IRS rules, which are prohibited by S-Corps. Any return is going to be a dividend to them if it's versus ordinary income as an S-Corp. And that you can create multiple classes for the investors or classes if you are looking at building out for an eventual exit for a sale to management. You can create an employee class of equity, and we'll talk about that a little bit later of how you created what you do. But as I mentioned earlier, one of the other reasons why I'm an opponent of C-Corps for successful companies where the founders are making more money than they need, focus on the tax rate of 21% versus 37 to 39.6% on that income. Then understand that simply, let's just say that you invested over a couple of years $500,000 into your company. You probably did that with less than 400,000 in actual cash because of the increased amount of after-tax income cash you can reinvest. And the favorable tax rate if you just keep it in the company versus the even more favorable tax rate of investing it in common stock. But there's a third alternative investment that's used a lot for this, and that's the idea of creating a non-qualified deferred compensation plan. And
you want me to go to that slide?
Go to that slide.
Okay. I want you to talk about this because I think this is something that's really important and is really beneficial to a lot of shop owners. Go ahead.
A non-qualified deferred comp plan is one of the few plans that can be offered on a completely discriminatory basis. You can offer, if you are a employee, you can just have it for just you. Unlike the S-Corp, where one, you couldn't even have a non-qualified deferred comp plan effectively with it. And it doesn't give you any real advantages to have a non-qualified deferred comp plan because you're not able to reinvest the profits at a favorable tax rate. But what a lot of clients do is use the non-qualified deferred comp plan to also deal with a secondary issue, and that is life insurance. And they will buy a life insurance policy. They will have a life insurance policy where they will have a low death benefit that will grow over time, but they fund it to significantly increase the cash surrender value, which then can either be repaid to when the person retires. It could be repaid if it's in the form of a split dollar. It could be if it's maybe part of the sale of the assets. It'll potentially come out partially as capital gains. And then if they don't need the insurance, they can just borrow it instead of and annuitize the life insurance by borrowing it out and not paying any taxes on that income.
Exactly.
The disadvantage, though, is because of the new Bartlett case where the Supreme Court has held that if you hold that insurance in your corporation, that death benefit is going to be part of the value of your business for estate tax purposes. There is a secondary seminar we can talk about how you deal with life insurance post-Supreme Court, the recent post-Supreme Court ruling.
Correct.
But this is a way to, if you've already maxed out your retirement plan, or you don't want to offer a real generous retirement plan to your employees, but you want to have a way better retirement plan, non-qualified deferred comp is a wonderful vehicle.
Right.
There's one big risk, though, and that is if something happens to the business, that non-qualified deferred comp plan is an asset of the company. It cannot go to the owner. So it is an asset at risk. So that is one thing to consider. But that also can have one other benefit, and that is certain businesses have bonding requirements.
Right.
Okay. Your insurance that's sitting in as your non-qualified deferred comp is an asset for bonding.
Right.
So by putting in that money and building up that plan, you are also increasing your access to business because you will now have a larger bonding requirement.
Yep. No, that makes complete sense. And it sounds to me too, even if you're using life insurance, by utilizing the lowest death benefit, you're going to kind of minimize any of the risks from the Conley decision. Is that correct?
Correct.
Okay. Sounds good. So do you want to go through some numbers here?
Yep. Let's show some numbers here. So basically, and this does not, and the one here does not factor in the dividend exclusion, which would increase, which would probably put the third column, between the second and third column would be a little bit higher.
Okay.
There'd be another number that would be slightly higher. But the concept here is if you look at this shows you what happens with the reinvestment. Look how much more you get to reinvest every year based on the lower taxes and then the lower reinvestment rate. So you got in the worst case scenario, you got probably 35 to 40% increase over 5 years with not very aggressive reinvestment rates.
Right.
If you obviously, depending on how you wanted to do it, you could have a portion that's all in dividend stocks. It's not going to appreciate. And you could put some in high flying, some in high flyers where you're going to pick up some gains.
Right.
And that's the other point I'm going to make. As long as the corporate tax rate stays at 21%, there isn't a very big deal difference for someone who is already in the maximum tax rate because there's only a 1 point difference between individuals and corporations at that point.
Right. Okay.
So something to consider along those lines.
Right. So, and that's why I think it's important to talk to attorney and tax planning, CPA, somebody who can help to identify what's going to be the best option for you there.
But as I said, the tax is a major piece, but in my mind, the ability to have multiple classes of equity for investors, for family, if you're going to put it into a trust, you can create different ones for investors.
Right.
But the other point is, if you are going to develop a management team, the last thing you want is to spend 5 or 10 years developing a group, someone, and then him leave you. So the idea of having some form of non-compete is really valuable.
Right. And I really want you to talk about this because it's amazing to me how many shop owners don't have even employment agreements.
Right. And at a minimum,
with tech shortages, I mean, employees in the collision industry are valuable, good ones.
Right. Which is why also another section we can talk about is the idea of training agreements when you are getting certifications.
Right.
But the idea here is that with the FTC ruling, which I don't know if it's going to stand, but most states have already adopted something similar to this as far as pure employees. So the question comes in is, how do you create a bindable and covenant not to compete today?
Right.
Well, the FTC, as well as all the states, have said one thing. That is, it's completely legitimate to have a covenant not to compete if you're buying someone out of a business, because it would not be reasonable to say, hey, I'm paying you fair market value for the business. And oh, by the way, you can go compete with me next. You can open up next door.
Right.
So that is completely legitimate. So the concept that I have been developing with a lot of clients is saying is, we can create an employee class of equity. That employee class of equity provides for what is known as vesting valuation.
Okay.
What that means is that if let's say that you have to stay 5 years to get full value and invest in 20% per year.
Okay.
So if you left after 2 years, you would get the higher of what you paid for the equity or 40% of the fair market value. So you ratchet up. They have their capital gain and their full ownership from day one. So once you get 12 months, they've got their long-term capital gain. But what you're saying is you're going to recognize that over a period. You're going to only get full value if you stay that period.
Right.
But what it also provides is that if I buy you out, 20% of that is into a funded covenant not to compete that's going to be paid out in equal monthly installments over the covenant period.
Mm-hmm.
And if I, as owner, think you're cheating, I pay it into an escrow. I can't use it as a funding vehicle, and prevailing parties gets their fees paid. So, Mr. Employee, I think you're cheating. You want to sue me for it, or can I take the escrow back?
Right. I think that's an important point. That may be a fear of the owner is, again, okay, so I start either bonusing or, creating these employee ownership shares, but what happens if they do leave? So it sounds like to me, this is a way that the owner can protect himself.
Correct. And we're going to show you that in a minute. But one other point that'll sort of go to the next session we're going to do on is you are any employee that ends up owning stock, it's now your partner.
Right.
Partnership is like marriage without sex. The only thing that brought you together was to create a progeny called the business. The only thing you're going to fight about are money and control. Your stockholders agreement is your business prenup, and you need to do it early on, or someone's ox is going to get gored.
Right.
We will talk about that piece of it in the next section, Matt. But that is so key that if you're going to do these kinds of transactions,
right,
it makes a lot of sense. Well, let's talk about one thing. Let's go back on the potential disadvantages. We've talked about the double tax issue.
All right.
As I said, I don't believe that in today's society, if you've got good financial records, that you really should have a problem with double tax, because you should be able to know how much to leave in the company so you won't have dividends you'll have to strip out later.
Okay.
So we can plan for that. Double tax on the asset sale is a larger problem.
Right.
The issue there, though, is what I have done with some of my clients is if they control the real estate, I have all of the equipment owned by the landlord.
I gotcha.
So they lease a fully turnkey operation. Therefore, I've taken out the one asset that's going to create a problem on an asset sale out of the transaction for double tax.
Okay.
You see, because now,
good.
Because otherwise, any asset sale, you're going to have to pay the owner's going to have to pay, you're going to have ordinary income on the recapture amount.
Right.
But as a dividend. Versus with the equipment's bought separately. It's an LLC. So also made it a lot easier, potentially, not having fights over sale price.
Right. Would that also be a protection for, let's say, parents own the business, kids are heirs, they're buying into the business, but also protection for the parents? Kind of like the old co, new co concept. I know they talk about a lot of BEI. Is that also help to provide protection?
Yeah. Well, again, the concept here is that if mom and dad are selling, and kids can still do a stock sale, and the only cost is the 17% tax increase on the ordinary income portion.
Okay.
And so the idea here is that I've built a template that I can compute out and say, okay, the taxes have increased by 35,000. If I'm going to end up where seller is going to be at zero, he needs 51,000, let's say, to pay the taxes on the taxes. But you zero it out.
Gotcha.
And the point is, buyer gets to write off that increased purchase price. But let's put it this way: he also gets to write off the entire purchase price, versus he gets nothing if it's a stock deal.
Interesting. Okay.
So think about it: you do a $2 million stock deal versus the other. You still get to write off, even if the equipment's $500,000. You get to write off $1.5 million as goodwill over 15 years. That still significantly reduces the after-tax cost of the deal.
Yes.
Which is why it's not unreasonable to say to the buyer, I'll let you do the asset election, but you're going to pay my taxes because you're still going to be way farther ahead.
Right. Exactly. And that makes sense. And I think that's really when, I think most owners at any point, I think their big fear is that how do we create these transitions and maintain control until the point where we fully want to get out.
And that can be done with, again, different classes of securities.
Right.
The idea here is your example of the guy who wants to get out over time but wants to be an absentee owner. You give him a limited voting preferred.
Okay.
It says, you have to present me the annual budget every year. If I approve the budget, ain't my problem anymore. Right. You want to go out and spend $50,000 on something, you get my permission. It's fine. Okay. You want to go increase the budget by more than 10%. You come back to me. But other than that, he's out of it.
Interesting.
So you have a distinct list of the things that would impinge his ability to get repaid. And he has effectively a veto over those.
All right.
And here's the other point that I have with clients. Clients will say, I love my kids. I don't know who they're going to marry. I don't know, I don't know what kind of kids my grandkids are going to turn out.
Right.
I don't want to give my kids voting equity necessarily.
Right.
Or do I want to give them equity at all? So this is where dumping it into a trust gives you, one, the advantage to clearly claim the minority and valuation discounts, which preserve more of your lifetime credit, depending on where that's at. But the point is, you can be the trust committee, giving you, the founder, the ability to hire and fire the trustee.
Right.
So your kids don't have the vote. They have the value of the underlying equity. They have the trust, but the trust is there to make sure that you have not lost control. So you can do it through voting control or setting up a trust that you control the trustee.
Right. Yeah, that makes complete sense. And I think, like I said, I run into this a lot where families, they want to be trusting. Sometimes they never think that these things are going to happen. Divorces, drug addiction, alcoholism, those kind of things within their kids' families, but they do happen. And I think it's really important. You got to build those protections in, not only for your family, but for yourself. So to me, it makes sense.
I'm doing something with one client that he is setting up his calibration shop.
Okay.
And he's bringing his 2 kids into it. One is a baby dad already, without marriage. One is getting married, and getting married soon.
Okay.
And what we have done is, he doesn't want to put the equity at risk in a divorce.
Right.
So the equity is all going to be held in an irrevocable trust. Their equity in each business is going to be held in this irrevocable trust. We'll send through the income, but the point is, if there's a divorce, it's not an asset.
Right.
They might count the income as far as as far as child support goes, but they're not going to get the underlying business asset. So
Right.
a lot of clients, when they have younger children, they want to start the transition, but they also know that, as my brother's fond of saying, don't get married before you're 30 and save your first divorce.
That's right. That's exactly right.
But they want to have their child who's under 30 being an owner. Jumping into trust makes a lot of sense as a way to make sure it's protected, that you don't get sucked into the divorce.
Right. Exactly. So just we're gonna kind of go because I know you've talked about different classes of stock. Let's just again kind of do it just a quick top view, just so people
Yep.
have the slide, they can see that. Hopefully, if you are listening to this, go to my YouTube channel, which is High Lift Financial, or you can go to my website, highliftfinancial.com, and click on the DFRAN Digest. And these will all be in here so that, if you're missing anything here or you want to see the slides, you can go there. But let's talk about just again, kind of give a review of the different classes of stock, just to kind of refresh the listeners and the audience.
And well, the first one I'm going to mention is that if you've got young management, they might not even be able to buy 1% with their situation.
Right.
So what we can do to reduce the prices, we can say, hey, I'm going to give you stock, but you don't participate as an owner effectively until there's at least $5 million of sales proceeds.
Okay.
So we can lock in a value. So now, if we're valuing the company and it's worth 10, I only have 5. 5's gone to, so therefore he's getting 1% of 5 rather than 1% of 10.
Right.
And it makes the owner feel better because he says, hey, you weren't here to build all this up. I should get credit for some of the stuff I built up before you joined. Okay. Right. So it helps get the pricing down.
Mm-hmm.
It also gives us the ability to give a preference, to compare it to the employee class.
Right.
The other issue that you're going to have is if you have multiple owners, what's the rules on death, disability, etc.
Right.
On your equity? How is that passed? You need to specify that.
Right.
Employees, with employees on that, it's usually going to be some form of buyback, and there are various things. So with employee equity, there are two sides to this. And that is, on one side, I don't know many founders who like to give up control.
Right.
On the other side is, what does it say to the employee that you don't trust them enough to give them a vote? Because you have supermajority anyway.
Right.
So there's a question of balancing the idea of saying, yes, I value your judgment, but I don't value it enough to give you votes, or I do. So just that concept.
Right. Right.
And so it's not automatic.
Gotcha.
We talked about vesting valuation, how that works.
Mm-hmm.
The idea that if they leave, if they die, if they have voting, it automatically converts to non-voting. Right. So you don't have them involved. You can build in change in control and stay bonuses. Let me explain this to you for a second. Concept is this. In most cases, if an employee gets a change in control bonus, it's all going to be ordinary income, correct?
Right.
If I've done this right, and the change of control has taken at least 12 months after the employee has purchased the stock, he's got capital gains.
Okay.
On 80%.
Right.
Okay. So now I can say, Mr. Key employee, what are you going to do for me? Well, what you're going to do for me is you get 20% at closing, and you get 60% at the earlier of 1 year after acquisition or 30 days after constructive termination. Change your job title, move you, cut your salary, and the balance is in the covenant. I would say most companies would like the idea knowing they got your employees locked up for 2 years.
Right.
You've also effectively funded a severance package for the ones they don't want to keep.
Mm-hmm.
You've given them a year to figure out if they want to change their compensation structure to keep this guy after the year, but they've still got him under a non-compete.
Nice.
Now, so I think that's going to add value to your EBITDA multiplier when you sell.
Right.
But it also does something else. How many deals have you seen fall through because the key employee is part of the LOI and he says, not unless I get $100,000.
Right.
And that blows the deal.
Mm-hmm.
Well, if you've taken them out before you have an LOI, they can't mess up your deal.
Right. Exactly.
Okay.
Yep.
So, and this is the other point. It's a funded covenant not to compete. Most covenant not to competes we're going to sue you. No, I'm holding money that I'm not going to give you unless you. So you've changed the litigation risk.
Right. Now you don't have to do litigation. It's
right. You can say you want to sue me for it.
Right.
Go ahead. You're going to pay my fees if you lose.
Right.
And I'm not going to probably be unreasonable.
Right.
And from the investor standpoint, you can give them limited voting rights or no voting rights. Mm-hmm. They have a preference. They can have a preference in dividends. They can have a preference in liquidation. They can have a fixed dividend or an escalating dividend. But the beauty is the dividend is going to be taxed at 15%. Most of your investors are probably in the maximum tax rates, so that their investment is going to be, their return is going to be taxed at 39.
Right.
So isn't that helpful to raise rent? What I talked about, what I mentioned to you is, and I'm using this also as a form of redemption for partners. If you have multiple partners and one wants to leave over time, setting up a redeemable preferred stock that is redeemed based on the profitability and based on the then fair market value allows them to participate in the growth, start the exit process now, and not crimp the company as it would necessarily with a note where you have to make the fixed payments.
Right.
This is tied to profitability. And I would say in a lot of the management cases, the owners don't like the idea of not necessarily, if the business goes completely under, penalizing.
Right.
And that's the other reason why the corporate redemption being the biggest piece map works so well, because if the company fails, the only one who loses is the founder.
Right.
Because they have no personal guarantees.
Right. Exactly.
The last issue is with investors. Do they stay if they die? Or do you have to buy them out? Do they keep voting? If they have voting, do they lose the voting? Because you're now dealing with kids and you may not want them to have voting.
Right.
So those are the various things you need to consider in the classes of stock.
Right. So, and I think that's what's actually going to get into our next topic about, preparing for those things like death, disability, family issues, those type of things. We're going to talk about that, but it's just a kind of final point.
I would like, Matt, let's go to the slide on what we have talked about having them buy. We were going to talk about getting the stock to them. Well, how do they actually get them the stock?
Right.
So the concept here, again, this works well with a C corporation. We've talked about the concepts of valuation discounts, lack of marketability, lack of control. Well, if this employee is also signed on to vesting valuation, a stay bonus, and a covenant not to compete, you might be able to discount that closer to 40%. Okay. So now you can go to Mr. Key Employee and say, Mr. Key Employee, do I have a deal for you? I'm going to sell you stock in my company for a note. I'm going to sell you stock in my company at 60% of the fair market value for a note that you're going to pay for out of my after-tax bonuses that I'm going to declare to you next couple of years. Zero-sum gain. You avoid the Section 83 problem of phantom income for the employee.
Okay.
And you started their holding period. Now, what I love is the math in this.
Mm-hmm.
And that is, let's say we had $100,000 discretionary profit.
Right.
Mr. Owner's tax rate, let's say, is 45%. So if he kept the 100, he'd keep 55,000.
Right.
Okay. Mr. Employee is younger. His tax rate, 75%. So if he pays that $100,000 for key employee, Mr. Key Employee has $75,000 that goes back to the company as payment on the note. Mr. Founder then can take that out at cap gains rate.
Oh.
So effectively, he ends up, if you said at 75,000 dividend, he ends up close to the same 54. He ends up with 54 rather than 55,000.
Right.
So it's cost him virtually nothing. The golden handcuff for key employee.
Mm-hmm.
Not a bad deal.
No, that's
and Mr.
Right.
Key and
Deal.
Mr. Key Employee is an owner. He's got the ego now. You've aligned his goals.
Gotcha.
Because he wants to sell the business just as badly as you.
Right.
You're now constraining because you know you got him locked in.
Mm-hmm.
And so now you can go either any way you want with growth.
Right.
And the point is, this is where if you are going to do a growth strategy, my big belief is you need to set up a holding company and each shop should be in a separate company.
Right.
If that's true, think about it this way. This way you can have employee equity in the holding company for the CFO and the people who are assisting all of the shops. And then you can have a similar employee equity in each shop for your GM or your estimator.
Right.
And he's also only going to want to see the profit based on his shop because most of them have ego.
Right.
And he's not going to want to worry. So this way, it's a way to golden handcuff on the shop level and on the upper end level.
Nice. I think that's a great concept. So like I said, we're going to be talking more about, planning for unplanned events, and this is one question. We talked about this and I'm sure the audience has it. We've been talking about all these benefits and all these ways to structure these things. The audience may be saying, Stuart, so why hasn't my CPA or attorney talked to me about these things? There's lots of S Corps out there, and I find very few attorneys and CPAs are talking about the benefits of being a C Corp. So why is that?
Well, first off is it only became beneficial after 2017 when you had the significant cut in the corporate tax rate, which was made permanent.
Right.
But it's really the CPAs will look at this and saying that you have double tax.
Right.
And my comment is, as I've said before, if your financial records are good, you really shouldn't have double tax. If you are not selling to a third party, you should not have any type of significant asset tax when you sell the business. And what I think is the CPAs don't necessarily focus on, they look at purely double tax without looking at the benefits of multiple classes of equity, the potential of doing gifting of stock for estate tax planning, the need to have a second class of stock to bring in investors or employees. They look at it from a pure number standpoint. And I still say that right today, the numbers are significantly in their favor, but even if the numbers were to change somewhat, The other advantages of also having a tax-effective non-qualified deferred comp plan. How do you factor that in to pure numbers? And that's where I'm saying that the CPAs who are looking at this, most CPAs are form fillers.
Yeah.
Very few are planners.
Right.
Those that are planners, if you said, well, what are the advantages of a non-qualified deferred comp plan with a C-Corp? They say there are some advantages to that, but they don't come up with that because they're not looking at it, because they're looking, double tax is driving them. And the other point that I've made to you is they need to plan at your year end.
Right.
Here's the point I'm going to make to you. They harp on double tax. Well, if they come to you, which happens to a lot of my clients in April, and said, oops, your K1 is going to have $100,000 more income in it, but they're going to say, well, but you didn't pay any extra tax for that.
Right.
Versus if they do that in a corporation and you have to pay, you got to pay $25,000 worth of taxes on money that you now are going to take out as a dividend, you're not going to be very happy with them.
Right. Exactly.
So from a client perspective, it's less risky for them as far as losing a client than the planning that they can potentially gain.
Gotcha.
So that's really the issue is their malpractice.
I get it. No, I think that's awesome stuff. So, Stuart, we're going to go, we're going to just take a break here, but for the audience, session 3, we're going to be talking about buy-sell agreements. And again, how do you build protections in, especially if you're, this is really whether you're an S Corp or C Corp, I think they're all, and you have partners, it's a really important thing to have. And again, like we've been kind of reiterating throughout these sessions, it's really important to dot your I's and cross your T's so that you're not exposed. We want you to maintain control as long as possible. So, Stuart, we'll be back in a little bit. For the audience, thank you for listening to this session of Your Business, Your Life. And if you're not subscribed to the podcast, please click the subscribe button below. That way, when a new episode drops, you'll be able to get all this great content that we're providing. And also, if you like what you're hearing, give us 5-star reviews on any platform, whether it's iTunes, Spotify, Google Play, or especially if you're listening to YouTube. And I think, it's really important if you are listening to this, go to the YouTube channel at High Lift Financial, or go to my website, highliftfinancial.com, and click on the DFran Digest. And this information will be out there. So anyway, we'll be back. We're going to talk about buy-sell agreements. And we'll look forward to talking to you guys at that point. So take care and God bless. Hey, I really want to thank you for listening to the Your Business, Your Life podcast. If you want to be notified when new episodes become available, click the subscribe button below.
All information is obtained from sources deemed reliable but not guaranteed. No tax or legal advice is given nor intended. Content provided herein or on our website should not be construed as an offer for investment advice or for securities, insurance, or other investment products. Investments involve the risk of loss and are not guaranteed. Consult a qualified legal, tax, accounting, or financial professional before implementing any investments or strategy discussed here. High Lift Financial is a DBA for DeFrancesco Financial Concierge, LLC. Investment advisory services are provided through Cornerstone Planning Group, LLC, an independent advisory firm registered with the Securities and Exchange Commission.